welcome the members here at M46 and on the virtual platform. Welcome the public protector with us here at M46, together with her legal team led by Advocate Mpofu. And I can notice that both of them have gone back to their roots. We envy that. Let me welcome the evidence leaders, Advocates Bawa and Mayosi, members of the media with us, and our entire support staff, the people who brought us here, the members of the public in your various platforms. Welcome to day 2 of this session. We will immediately not waste any time and hand over and ask Advocate Mpofu to kickstart the proceedings. Are you settled, Advocate Mkhwebane? Okay, thank you. Over to you, Advocate Mpofu.
Thank you very much, Chairperson. Good morning. And thank you for those remarks. Namhlanje ukenza ubuza ngesixhosa ngoku. Ungandivaya kandiva. No. Now, good morning, Public Protector.
Good morning, Advocate Mpofu Lochan.
Yeah. Ninjani. Thank you. All right. Now, we left it off yesterday where we said that today we're going to get into, shall we call it, the meat of the issues. The term that I borrowed from the chairperson yesterday was landscaping. And it was a correct term. And we're happy that the chairperson allowed us to do that landscaping. Because, as I always say, once you set the scene, it might look like a waste of time, but actually it saves time, because it means now when we get to the actual meat and the charges, we don't have every time to go back to that overview because the foundation has been laid. But having said that, Chairperson, it's inevitable that we have to anchor the evidence back to the overview without over-elaboration. I mean, we're not going to take a day every time we have to do that overview. So maybe, Chair, before I do that, if I can just address a few issues to you directly. One is the issue that you discussed in your meeting last week about the funding of the legal team and all that. We just wanted to record, Chair, that we know that it's not your issue, but you were simply copied like everyone else. But just for the record, that it's a matter that we know we're seized with. Unfortunately, the last few days have been hectic with statements and courts and so on. So we'll take advantage of the few days break and be able to respond. Then, Chair, we also want to flag the fact that we are concerned about the length of the evidence and the number of days that have been provided. But again, we'll assess that. I think after today in particular, we'll be in a better position to engage at this level or at the level of the back room as to what, so that by the time we come back the next week, we'll have a sense. I know either to say how much longer or shorter. I know you want it to be shorter, but we'll be able to assess. particularly after today. Thanks, Chair. Now, Public Protector, I was saying that...
Thank you for putting those measures on record. They're well noted. Thank you.
Thank you, Chair. Yes, I was just saying to the Chair that we will now and again go back to the overview, but really for the purposes of making progress. Because remember, every charge will have its own quote unquote mini overview, because that particular report has got a particular context. But we're not now going to go back to the broader issues, except for the purposes of addressing a particular charge. So that's the mode we're in now. So in that context, I then want to recap that yesterday you explained to the chairperson and the committee why it is that in your resequencing of the charges, you are going to start with the CR17 Busasa matter. Correct?
Correct.
Yes. And you explained, I think your words were that this is one of the matters that this whole thing is all about, that have brought you here in the context of the words in the Nkandla case, correct?
Correct.
All right. So we are now then going to zoom into that particular charge, but I thought again, just to put it into its context, we, as we did when we were dealing with this charge with Mr. Matabuche, we always have to keep the eye on the ball, really. And I think, Chairperson, I'm now addressing you, Chair. This kind of, we're all in unprecedented territory. And as we said, all of us have a responsibility to shape this. Nobody else has done this before. So we need to find a methodology that works for all of us, but one where we're on the same page here. Unfortunately, there's no precedent that we can look up to. So I think we owe that to the nation anyway, to try and design a framework. So in that spirit, then one of the things that I think we need to do is always to focus on what we're not doing, if you know what I mean. So, for example, Chair, we are not here when we talk about CR17, Busasa. It's important to communicate this frankly to the nation and to everyone, that we're not here to redo the Busasa report. Otherwise we'll be here for the whole month. Yeah. Neither are we.
Very important point.
Yes. Neither are we here necessarily to second guess the findings or try and amend them, because the report is the report. We can't change it. And thirdly, Chair, we're not here to rewrite the judgment either. The judgment is the judgment. So the example I thought of to make this point was, if let's assume this CR17 thing had featured in the Zondo Commission, and then there was some new evidence, like video evidence of money being given and so on. This committee cannot be concerned with that, because this committee is looking at a point in time, which would have been before those revelations or whatever. So we couldn't then come here and say, no, Chairperson, let's play this video of what happened in the Zondo Commission to show that the public protector had this. That would be a false methodology. So what are we here for? We're here for the simple task of looking at the charges that this public protector is facing before this committee. And those charges have been defined by Parliament, not by the committee. They've been defined by the Parliament. So we have to look at that definition. We don't have to reinvent the wheel. We don't have to or follow our hearts or whatever. Misconduct is what misconduct that has been defined by Parliament. If we want to change it, we'll have to go back to the House and change that definition. But for now, we're all confined to what it is. So that's the first level, which I think we must always keep at the back of our heads. The second level, Chair, which really is where I'm going now, is then having understood that what is misconduct, what is incompetence, and whatever, we then have to say, as we're doing now, which charge are we now dealing with? And we're dealing with essentially now 11.3 and 11.4. Then we look into the mechanics of that charge and the specific allegations. And that's all, really. And then the committee in the end will say, this charge and this charge, yes, no, or whatever. And maybe the last point, Chair, is that we also, although it's not easily separable, there's no point in putting the legal argument to you at this stage, as it were. We must try to get into the facts. Yeah, we will get an opportunity to do closing arguments, and then we'll say, no, this fact means that, this fact means that. Yeah, it's not always easy to make that separation, but we must strive to if we're going to make legal argument, it's really just to plant the seed, but not to focus. So that's, Chair, is what how we propose to approach this, so that we don't waste time on, as I say, on what this process is not about. All right.
Chair.
Suppose Advocate Mpofu, Advocate Bawa.
Sorry, Advocate Mpofu, so
No problem.
that we're on the same page. And so that we have some agreement on the ground rules, because it seems as if we could make common cause, and the common cause would be, actually, we're not rehashing the facts, we're not redoing the report, and we're not looking at new evidence on the facts that emerge subsequent to the motion being lodged. Is that how I understand you to say?
Sorry. Yes, more or less, except the first one. The first one is, I don't, that's not what I said. The facts, I'm trying to say we must focus on the facts at this level. That's what a witness is here for. So it's inevitable that sometimes we'll put legal propositions and so on, but really we just want the raw facts. The legal argument of what is the meaning of those facts and what it is not, you and I will debate at the end. So that's the first thing. But the rest of what you said, I agree. We don't have to, we can't redo the report because it's there. It was done, it was signed and dusted. Neither can we rewrite the judgment.
There's just two issues that I thought we must just clarify. On the legal issues, some of the issues of misconduct and incompetence that appear do emanate from legal propositions.
Of course.
That I may have to put to the public protector when it comes to that
Sure.
point. So I may want to say that you're upfront so that you're aware in case you want to canvass those issues.
No,
with a
Chair,
meaning that
I accept that. I accept that also on the basis that this is not just a witness, it's the public protector. The reason why she's the public protector, all this the stuff we're going through yesterday. She's legally qualified. That's one of the qualifications of being a legal public protector. So inevitably, when you put questions, or even members, no one can stop them from testing. Well, how did you come to this conclusion if you had this evidence? That kind of thing.
Sure. Thank you.
and then the second thought that I had as you raised this, Advocate Mpofu, was there is, of course, the exception of where an appeal judgment only came out after the motion had already been finalized, even though the High Court judgment existed at the time.
Yes.
That obviously that bears on
Yeah.
on some relevance,
Okay.
irrespective of which way that goes.
Yes, Chair.
Thank you, Advocate Bawa.
Yes, thank you, Chair. Again, this is very important. And ordinarily, as I say, because this is unprecedented, ordinarily we would have this kind of exchange when we do the legal argument.
Yeah.
But Chair, with your permission, I think it's important that you allow it, obviously, within bounds, because it focuses, in my view, it will focus all of us, focuses the witness, focuses the members, and it will limit unnecessary evidence, so to speak. So then maybe to respond directly to the point you're making. Well, you're saying that when is the point you're making for now or for the legal argument?
No, I think that I accept that this is not a hearing. I am in agreement with you that we are not here for the committee to reevaluate all the evidence that informed the public protector's reports. But there are judgments that have been handed down, which is referred to in the motion. And then
which were superseded by,
which are then superseded by appeal court judgments. Let's take the SARS unit judgment, for instance, whereas at the time the motion was written, there was a high court judgment. You guys had appeals pending. There has now been finality in respect of that.
Good.
So that has some relevance or bearing on it. And in the same way, if the full bench decision in the Western Cape that you argued at the Concord, or it gets argued, comes out, obviously that there's now finality on that issue that has a relevance to which should be referred.
No, I understand, Chair.
So you're done with Bawa, so that we allow him to start.
Yes, Chair. Before I start, let me just respond to that and just give you an assurance, both to the committee and to Advocate Bawa. We're not going to be taking technical points at the end and say, and the SARS issue, Chair, is a good example. Both SARS, I think, and CX. So we're not going to come here and say, oh no, you can't talk about the Constitutional Court judgment in SARS, because when Ms. Mazzoni drafted her motion, that judgment was not out yet. We're not going to do that. If we were going to do that, really, we would be making a mockery of this process. I know that in the actual motion, as far as the SARS matter is concerned, that is the commissioner for SARS, the charge that is, or rather the judgment that is cited, even in the amended motion, is the High Court one. And as Advocate Bawa says, that was because the Concord one had not yet happened. But it would be ridiculous if we're now going to say, well, the charge is the four corners of the charge. Because actually it would be foolhardy for us to do that. Because what if, for example, in one case where the Concord would have come to agree with us, then if we're now going to say, no, you are confined, it means even us, we won't be able to take advantage, quote unquote, of any favorable finding. But so should the evidence leaders be able to use any subsequent finding. You can be sure that we're not going to do that.
Okay.
Thank you,
Chair. Let's not eat too much into your time.
Yes.
Please.
Thank you, Chair. Right. So now, Public Protector, what I want to do then is to start with this session by taking you to something that is effectively one of the of the standard methodology templates that is contained almost in all your reports. And it's something that I like it for simplicity, because sometimes lawyers like to complicate things unnecessarily. And it is that template that you use for saying what happened, what should have happened, and so on. And I think it makes it easy even for members of the public to follow how you do things. Can you maybe assist the committee as to where that formulation came from? Did it come from you? Did you find it there already? And what does it entail? So.
Thank you. Good morning, Chairperson, members of the committee, evidence leaders, the staff of Parliament, my family, members of the public protector staff. This formulation, it was developed by my predecessor. It's one of the things which, when we were deliberating at the think tank, I said it's well crafted and indeed it's simplified. It's something which we can continue using because it's true that when it's not broken, why fix it? So that's what we are using, and indeed it's very simplified. And I must indicate that it's what we've been doing, and I think that's what I will be comfortable today to deal with, to answer the charges and to deal with everything I relied on at that particular time to come to the conclusion of all these reports.
Yes. And maybe before we even get to that, just to situate the discussion that we just had now with the chair and the evidence leaders, for the sake of completion, for you to confirm that that is the framework that we will be following in dealing with your evidence and arguments and what should guide the committee when it does its report. Would you confirm that framework or want to add something to it?
Yes. I wanted to say you are speaking over me and I'm sitting here, but we discussed indeed that's what we'll be doing. We are not starting the investigation, but what committee members and the public should know, and which I'm saying, I will have to take the public into confidence on what was happening when all these matters were investigated.
Correct.
To prove the issue of competence and to prove the issue of doing my work without fear, favor, or prejudice.
Yeah. Okay, good. Thank you. No, that's exactly why I think the chair allowed me to put that question so that we don't have some side agreements which you can say later, well, that I was watching you talking, and that's not my approach. Okay, thank you. All right, so now that we've got that out of the way, which I think will save, as I say, a lot of time and a lot of bickering. Yes, let's go to page 550, Tsepo, so that we're all on the same page as to what we're talking about now. Big 550, small page 54 of the public protector statement. Right. So I'll just read it out, Chair, for speed. 124. Yeah. So that's for the benefit of the members. That's the matrix or template that we're talking about. So it says, like every public protector investigation, the investigation is approached using an inquiry process that seeks to find out, 1, what happened, 2, what should have happened, 3, is there a discrepancy between what happened and what should have happened? And does that deviation amount to maladministration or other improper conduct? And 4, in the event of maladministration or improper conduct, what would it take to remedy the wrong or right the wrong occasioned by the said maladministration or improper conduct? Very simple way of explaining a complicated process. Right. So, and we've already, you heard in the other exchange that all that for the purposes of this exercise is not necessarily to redo the report, but to what we're really inquiring into, if you like, is what was happening in your mind, to put it simplistically. Yeah. Were you motivated by, if you made a mistake, for example, was it an honest mistake that anyone can make because we're all human? Or was it motivated by some intention either to target this one or to exonerate that one? We've had that discussion with witnesses like Ms. Mkhwebane and Mr. Matabuch. You understand that?
Yes, I understand that, Essie. And Chairperson, I will propose that you also, when you go through paragraph 125 and 126,
Okay.
which influenced what was happening when those investigations were conducted by the investigators.
All right, yes, I'll read that into the record as well. It says, the 125, the question regarding what happened is resolved through a factual inquiry, relying on the evidence provided by the parties and independently sourced during the investigation. 126, the inquiry regarding what should have happened focuses on the law or rules that regulate the standard that should have been met to prevent improper conduct and or maladministration as well as prejudice. 127, the inquiry regarding the remedy or remedial action, which we dealt with yesterday, seeks to explore options of redressing the consequences of improper conduct and maladministration where possible and inappropriate. And I think for the sake of completion, we read 128 because that's important. It is in the important case of public protector versus bail and guardian, the SCA made it clear that it is the public protector's duty to actively search for the truth and not wait for the parties to provide all the evidence as judicial officers do. Again, this is a point that's been repeatedly made here, but I think that should assist then the members to situate the core of what you do as public protector. Thank you. Right. Okay. All that's enough overview material for today. Then we have to focus on the specific charge and the specific rather specific charges that are relevant to the CR17. All right. Now we know that and I'm paraphrasing just to save time, charges 11.3 and 11.4 really focus on allegations of, let's call it favoritism on your part. You favor this one and you disfavor that one. I'm putting it very roughly, but you get what I'm saying.
Yes, I do.
Sure. Thank you. All right. Now, take us through, please, then walk us through without going into blow by blow. You made the point yesterday, again, we won't revisit that you don't go around standing in the street and say, hey, please, I'm looking for complaints. Or I want complaints against Mr. Janchi or this one. People complain to you and then you have to act on that, correct?
Correct?
Right. So then take us through what happened in this particular, how did this particular complaint come to your desk?
Yeah, okay, thank you. The investigation of the CR17 report, I think that's what we will call it, CR17 or Busasa report, emanates from my decision to investigate and report on the CR17 campaign of the then Deputy President, Cyril Ramaphosa, for the African National Congress leadership in December 2017. So this was a complaint lodged by Mr. Mkhwebane during November 2018. And in January 2019, another complaint was lodged by Mr. Floyd Shivambu.
Okay, sorry, I know everyone knows these people, but for the record, in what capacity were they, I'll ask a leading question. Were they members of parliament as prescribed in that act?
Yes, Mr. Mkhwebane was a member of parliament and the leader of the Democratic Alliance.
Thank you. Just a pause, but Projector.
Sorry, Advocate Mkhwebane, I don't want to interrupt you.
Sure.
But it seems to be that you're at paragraph 250, 251 of the statement. Would it assist the members if we put that on the screen?
Put it on the record, okay.
Okay. Thank you.
Chair, can I do that?
Thank you. Go ahead. You can switch it on again because when the third one comes in, it automatically goes off.
Yes. Thank you, Advocate Bawa. Yes, I think that will help us with this session. I mean, this part of the questioning. I'll just put it on the record. The members will be referred to 250 and 251. That's on page 610 of the statement. Small 114 tempo. Yeah. And it reads as follows. How this charge is formulated makes it difficult for me to respond. It gives an impression that the complainant was on a fishing expedition. This charge is not only confusing but prejudicial to me as it fails to deal with specific allegations or even name the politicians whom I allegedly disfavored and or favored. Okay, that now goes to 11.3 and 11.4 per se. We confirm that, Papa Prater?
Yes, I do.
Thanks. Then the next one is 251. The CR17 report emanates from my decision to investigate and report on the CR17 election campaign of the then Deputy President for the ANC leadership in 2017, which would inevitably lead to the presidency of the Republic. During November 2018 and again January 2019, I received complaints about President Ramaphosa. The first complaint was from Mr. Mkhwebane, the then leader of the DA. Complaint was related to the relationship President Ramaphosa, or rather of President Ramaphosa with a company called African Global Operations, formerly known as Busasa. And the following information appeared from Mr. Mkhwebane's complaint. Okay, I won't read the details of the complaint here. But that's the background. That's how, in answering that question, I think Advocate Bawa is correct. How the matter came to your desk is then captured in those two paragraphs, correct?
Yes, it's correct.
Okay.
And especially because they were members of parliament and they are the ones who are allowed to lodge a complaint under the Executive Members Ethics Act.
Right. Okay. Now, and again, until there's an objection, I'll lead on the non-controversial background. I'll ask you in the form of leading questions. It is indeed so that, and most South Africans know about this, that really the origin of this whole thing was a parliamentary question put by Mr. Mkhwebane to the president in the normal Q&A sessions, which ironically had nothing to do with CR17 or anything of that sort. It was about, at best, allegations of some money coming from a questionable company to the president's son. That was it.
Correct.
Yes. Okay. Again, Chair, I am not going to read the actual question and the answer. It's all there. It's in the report and it's in the statement here. But essentially, what Mr. Mkhwebane, the leader of the DA, wanted to know was about the payment of a certain amount of 500,000 rand by this so-called Busasa company to Mr. Andile Ramaphosa, correct?
That's correct.
Right. And I think this is very important because I think had the matter ended there, that would have been, we would not be sitting here debating that matter. Because the president answers questions all the time. And that's the, the question and it's answered and that's the end of it.
That's correct.
Yeah. But in this case, a couple of weeks later, the president himself, and this is where the CR17 comes into the picture. The president himself then wrote a letter to the speaker to say, no, that answer I gave was wrong. About, I looked at my son in the eyes and all that, and I'll take him to the police station. Actually, that 500,000 was paid to the CR17 campaign, right?
That's correct.
Good. And that's how we then got to the rest, as they say, is history.
Okay, just pause. Advocate Bawa.
Chair, I understand Advocate Mpofu's leading the witness for purposes of saving time and wanting to get through facts. But there are times when Advocate Mpofu's characterization and adjectives are different to what's in the affidavit. And I just want us to be clear that we don't describe evidence to the public protector or whether it would create some confusion later. So I just want to raise that to make him a...
All right. Okay, Chair, yes. First, well, I agree with the fact that it's a leading question, but it's not a leading statement. That's why it's a question, so that the witness can confirm. If the witness thinks that there's something wrong with an adjective or whatever, she can do so. But also, if Advocate Bawa feels so, I think she's also allowed to point it out. Yeah. But I get what she's saying, that there might be a particular nuance in that's what's wrong with leading questions generally. All right. So subject to that, you accept, let me put it as dryly as possible, that subsequent to answering the parliamentary question, the president sought to correct it by putting what he was presenting as the correct facts. I think if you do it like that without adjectives, do you confirm that?
Yes, I confirm that, and I think that is also captured in the report. Chairperson, and I will propose that. Well, she's indicating that we go through the statement.
Okay.
But the issue is very important that let's go through the statement so that, because we are doing this, as I said, for the members of the public to understand what I received, and especially the fact that I'm targeting individuals. And I indicated to you that somebody was even asking me, are you fighting the president? So that people can know that within my responsibilities, this is what complaint we've received. This is where the facts, I mean, everyone saw it, but then some people might not have seen it and they are listening. They just want to understand what happened. Thank you.
Yes, no, that's fine. I think then let's do it like this, because it looks like my effort to try and save time is not successful. You go through the statement and let's do the other way around. When I want to interrupt you to clarify something, then I'll do so. So Yeah, all right. Then let's go from 251.1.
Yes.
Because yes, indeed, the people at home don't have the statement. The members do have, and let's rather than have it from your side. I was just trying to speed it up here. Okay, let's start at 251.1. Public protector, because
yes, on the 18th of October 2017, according to the complaint, was that an amount of 500,000 was paid into the EFG2 Trust Foundation account by a certain Mr. Fenter, Petros Fenter, on the 18th of October 2017, on the instruction of the late Mr. Gavin Watson. So the 500,000 was part of the 3 million, which had been transferred from Mr. Watson's personal account by a Natasha Olivier, the PA to Mr. Watson, into the account of Mioto Trading, which was the company of Mr. Fenter's sister, Miss Margaret Longworth. So that was the complaint. And then that the money was paid from a personal account of the late Mr. Watson, the CEO of, he was the CEO of Busasa. So then the money was transferred to the account of Mioto and the company which was closely associated to Busasa. So that was the complaint, and that was said to be the money paid into EFG too. So as we've explained, I think I'll also try to just pick up important issues. Then on the 6th of November 2018, paragraph 2.5.1, 251.4, during a questions and answer session, indeed, Mr. Maimane presented some documents to the president that there is a proof of payment and a sworn statement alleging that there's money paid to Mr. Andile Ramaphosa. So the president confirmed that he was aware of the payment, but had been satisfied that it was a lawful payment of services rendered by a consultancy firm owned or operated by his son, Andile Ramaphosa. So it later transpired that the president's answer to the parliamentary question, or to that question, was false. So on the 16th of November 2018, the president sent a letter to the Speaker of the National Assembly, purporting to correct the answer he had given in the National Assembly on the 6th of November 2018. In the letter, the president confessed that the payment was actually a donation towards his campaign to be elected as president in 2017, December 2017. In his complaint, Mr. Maimane alluded that he was concerned that there was a possibly an improper relationship between the president and his family on the one side and the company African Global Operations on the other side. So to confirm what you said earlier, that he is the one who raised this issue of December 2017 in the letter to the speaker. So that's what it was captured, or the evidence which we then also considered.
Good. Thank you very much. It's okay. Let's then just, okay, well, we don't have to deal with that segment because I already asked you questions.
Then a second, okay.
Yeah, you can carry on.
Yes, in fact, maybe before then the issue of my determination was whether the payment of the said amount as a donation of to the campaign was proper, and whether it did not amount to money laundering due to the money having had to pass through several intermediaries. And this was actually exactly what Mr. Maimane said in his letter of complaint, not to say it was from what we have uncovered as the public protector, because that's not our mandate. And then another complaint was received from Mr. Floyd Shubavambu, the deputy president of the EFF, and his complaint was premised on Section 4, subsection 1 of the Executive Members Ethics Act. I think we were supposed to say Executive Members Ethics Act, in respect of the alleged breach of the Executive Ethics Code by the president. in appearing before the National Assembly on the 6th of November, when he was responding to this particular question about the 500,000 donation. So that's what we did. So as this was a separate complaint, normally within the office, if the complaint is similar or it relates to the same facts, then we merged this complaint to the one which was lodged by Mr. Mkhwebane of the DA.
Thank you very much. And sorry, just for the sake of completion, can you, you jumped to 53. Can you just read 253? Because I think that's what gives context as to why this particular company, I mean, if a particular company had given money to the president's son, so what? So the issue is why did Mr. Mkhwebane identify this particular company for any suspicion? 253?
So Mr. Mkhwebane in his complaint further alleged that Busasa was widely reported to have received billions of rands in state tenders. He further stated that he was concerned that the president may have misled the National Assembly in his reply to the question on the 6th of November 2018, and that the true facts of the matter needed to be established.
Right. Okay. All right. Thank you. So at least as far as Mr. Mkhwebane's complaint was concerned, it had two legs. One was the credentials or lack thereof of the company itself, and secondly, the question of misleading of Parliament. Okay, good.
Correct.
Right. And Mr. Shivambu's complaint, you've already paraphrased here. All right. Okay, now the issue of the benefit, the alleged benefit to the president or deputy president, and I'll be saying the president, but I think everyone knows that at the material time, he was the deputy president. For the purposes of Section 96, it doesn't matter. He was a member of the cabinet.
Correct.
Okay. Now, can you take the committee through the issue of the benefit? Just explain why if it's a personal benefit, then it attracts the disclosure under the code.
Okay, I think that is in paragraph 259. So during my investigation, I received evidence that showed, among other things, that there were monies transferred to the Cyril Ramaphosa Foundation, that Mr. Watson was present at the fundraising dinner hosted by Mr. Ramaphosa, and that on the 17th of November 2017, Ms. Donay Alain Nicole, the president's legal advisor, sent an email to the president regarding fundraising and events. So this is the email which Donay sent to Mr. Ramaphosa. Hi, please find questions, notes around fundraising events. I've tasked PG to raise about 15 million. He has gone Johnny Coplin on board and is meeting a few other people. He's suggesting an event with 15 to 20 people on the 24th after the NEC. Is this possible? I think we should still schedule the following: cocktail with black business, maybe 30, including more sake and other, sake, others. Cocktail with the Greeks suggested by Theo. You said yes. You have said yes, just trying to prioritize and get into your diary. People I need you to call, please, Mick Davis to coordinate.
Sorry, can you pause there?
Yeah.
Just go back a little bit. Yeah. Okay. Before we get to the next section, which of the email, I just want to put a few questions to you. One, just for context, so that everyone knows what we're talking about. This, who wrote this email?
It was Miss Nicole
And
Done.
who was it addressed to?
It was addressed to President Ramaphosa.
Right. Okay, so when it says, for example, you have said yes, the you, it would be Mr. Ramaphosa.
Yes, it was.
And where she
directed-
says, I think we should do this, then that's her making whatever suggestion. Yeah.
Yes.
Okay, I just wanted that for context. Then it says, this next sentence is important in relation to the next sentence. People I need you to call, in other words, people that Ms. Nicole wants Mr. or the President Ramaphosa to call, and then, okay, you can carry on.
Yes, they are this Mick Davis to coordinate a group from London, including Martin Moshal, ask for a collective of 20 million. Eric Sampson to thank him for the money and ask for another 10 million. Can I ask the following for money?
Chair.
Tony,
Joseph Boyce, Public Prosecutor, Advocate
We've-
Bawa.
We had been very careful about not showing people's names and phone numbers. Up to now, and there
okay.
seem to be
Yeah.
phone numbers on
Yeah.
the,
Okay, no, fine. I think we can block the phone number,
No.
but the names are there. They're there.
and there's an account number that comes up in the.
Yeah, no, fair enough. Okay, we'll watch that, Chair. Okay, just move, you know what, move the thing to Eric Sampson. In other words, the number one that don't show on the screen. Yes, they started number 2. Okay, carry on.
Eric Sampson to
Hmm.
thank him for money and ask for another 10 million. Can I ask the following for money? Tony,
Georgiadis, I think.
yes, Georgiadis, Kojo Mills, David Ngobeni, Paul Icon, request for meetings, Paul Icon, Steve Ratau, Paul Guna, Mane Dipicho. So
Right,
this were the this was the evidence which we collated during the investigation.
all right. Now, okay, let's stop there. Because when we deal with what I call the base documents, this becomes a central theme. And Chair, again, for the sake of progress, well, we want, but we also can't show all the emails and all that. I think the role of the emails, if you show 1 or 2, what we're really after is what role did the emails play rather than the contents per se. But so that's the first reason. The second reason is that even if we had all the emails, we can't show them because they are sealed somewhere in Gauteng. So these ones we can show because they come from the pleadings, not from the sealed documents. Yeah. Okay, fine. All right. Can we then go back to paragraph 258 so that we deal with what I'm going to call the base documents, which we are going to use in your testimony. 258.
Maybe as the before 258, or I thought you were still following up.
Okay.
So I think this also was showing that during the investigation and the fact that the interviewing of, we're still going to deal with those. We did interview Nicole Udone, we interviewed Mutlatsi, we interviewed Chauke, we interviewed the president, and I think Mr. Fenter, yes, but I just want to deal with the issue of the involvement of the president in the process, because those were some of the issues which, when we go through, you'll see why we are saying he was aware, because they were saying, no, we only invited him to the cocktails. Actually, even in the letter responding to the speaker, in fact, responding to us, was saying, no, I was not involved. I didn't know anything.
No, we'll get to
So
that.
yes, that is what we've captured
Okay,
in the pleadings. Yeah.
thank you. Thank you. No, we'll get to that and we'll analyze what, as I said, really what we're after is your reasoning.
Why? Yes.
Yes, and why you came to certain conclusions, whether it was for all the nefarious reasons that are alleged in the charge or that it was not. Yeah. Okay, so I wanted us to just, before we do that, because that information emanates from what I call the base documents, for lack of a better word. So can we first tell the committee what those base documents are at 258?
So it has already been established, and I hereby confirm that the key documents which will be used in my evidence to rebut the allegations into the charges which emanate from this Busasa report are the CR17 Busasa investigation report, the pleadings in the Constitutional Court appeal, especially my founding affidavit, the Constitutional Court judgment, especially the minority judgment of Chief Justice Mkhwebane, various newspaper reports which detailed information regarding donors and recipients of CR funds. And I think this is because the information which we also had in our possession. The recordings of interviews with some of the key players, and the recent SABC interview making reference to foreign funding to influence the 2017 ANC conference outcome in favor of President Ramaphosa.
Right. Okay. Now, with the exception of the last item, because we've already said that anything that happened post the report is really merely for context. Those other 5 source documents are before the committee, and I'm not sure if Temgosi finally managed to open the recordings. I know there was some technical problem, but anyway, putting technical problems aside, all those documents are before the committee.
Yes.
Okay.
Go ahead.
Thank you.
And
the recording won't show that part.
Okay, yes, correct.
Thank you. No, sorry, I was signaling to Temgos. All right. Thank you. Okay, now let's then come to the evidence you are leading. Whether you are dealing with the High Court judgment or the Concord judgment, for the purposes of what I'm going to ask you, it doesn't really matter because both of them made the same finding. Concord confirmed the High Court, correct?
That's correct.
Right. Now, without getting into the detail of the specific emails, it seems that the president's version and that of his CR17 managers was that the president basically did not know about the activities of the CR17 campaign. He was intentionally insulated, what in business we call Chinese walls. A Chinese wall had been built between him and the CR17 so that he didn't know what's happening on the other side of the wall. Can you just paraphrase, maybe in your own words, what the version was from your interviews with the people that you have just mentioned?
Yes, the interviews which were conducted, as I said earlier, we interviewed the Donay, Mutlatsi, Chauke, and They were saying that they were the campaign team, because that's what, when we wrote to the president, we met with the president. Indeed, he confirmed that he didn't know anything about that. He was told, we will be running this process for you, but then you are not going to, in fact, we are not going to tell you anything, but then we will invite you, or he was invited, or people were invited to attend dinners and events for the fund or the fundraising events. So that's that's the information which we were given when we interviewed those collective.
Right.
So it's there in the report, and I know you might take us there as well, or members of the committee.
Okay. Now, all right. No, we can go there. All right. Now, this, if you can still remember, how many times did you have to interview the president?
We met twice. The first one was when the letter of we normally call it, in fact, the first letter where we informed him about the investigation. We also requested all the evidence which he is having about this matter. So after the letter was drafted, it was then delivered to the president to make sure that the process is, or the investigation is conducted in such a way that there is no leakage or compromising the investigation.
All right. Okay, I think the part you wanted to refer the committee to in the report, you'll be found at 5.1.10.9.7. Sorry.
Yes, it's the main paragraph is 5.3.10
Yes.
of the report.
Yes. Can we start at? Oh, sorry, it's bundle E, item 10. Number 1. That's the Busasa report.
Are you winning? Slow tipper? Page number?
Oh, of the typed page of the
Page 41. Is
43?
that 43?
Actually, 43.
Okay, thank you.
Whilst she's looking, because in the report, the first meeting was on the 29th of January, 2019. Yes.
Okay. The first meeting with the president was?
29 January 2019. It's in paragraph 5.3.4 of the report, where it says issues in dispute. Yes, paragraph 64.
Yeah. All right. Okay, I wanted us to start at 5.1.10.9.7 so that we don't lose the point you made earlier about what I call, quote unquote, the Chinese wall. Can you read that into the record?
Okay, so it's 5.1.
10.9.7.
I know. 0.1.10. Okay.
You also have it on the screen.
That's with according to.
Chairperson, I must look for my second eyes.
Okay.
Yes, that's
All
why I
right.
prefer to read here.
That's fine. Okay.
Yeah.
We'll wait for you.
Okay, it says, according to President Ramaphosa, a deliberate decision had been taken by himself and by those leading the campaign that he would not be involved in fundraising, even as he would address meetings and have a few dinners with potential funders. These meetings and dinners were with potential funders were used as occasions where he would have outlined his vision for the ANC and the country.
Yes. Okay. Now, this, you would agree, this is what is at the core of the CR17 issue, correct?
That's correct.
Yes. Let's put aside now the issue of misleading Parliament and what have you.
Mm.
But as far as the CR17 issue, this was what I call the version, which was the president's version and that of the CR17 managers. I think that's what they're called.
Correct.
Right. Okay. And so that's what we're going to be interrogating.
Mm.
And we need to, again, keeping the eye on the ball, that we are following your logic as the public protector rather than anything else.
Mm.
Now, this version, in your finding, were you able to accept this version or this defense, quote unquote, of there was this lack of transparency, or did you reject it? If you did, then we'll go to the specifics.
This version was unacceptable because I've shown, or the emails I've read earlier,
Mhm.
because there would be a lot of other information which proved that the president was involved or he was aware about those donors and funders.
Mm. All right.
And to stress again that by then he was the deputy president. And that's what we were investigating and what Executive Members Ethics Act says about members of cabinet and as well members of parliament.
Yes.
About declaring any donations.
Right. Okay. So again, I don't want to belabor this point, but just so that there's no debate in anybody's mind, on the president's own version, because we must not portray as if the president said, no, I don't know what dinners are you talking about there. So on his own version, he had attended and addressed these dinners of donors, correct?
That's correct.
And more importantly, on his own version, at these dinners, two things were discussed, broadly speaking. His vision for the ANC and his vision for the country.
Correct.
Okay, all right, fine. We'll then come back to that here. All right, then you can take us to the paragraph that you wanted to highlight on the same vein. It was 5.3.
Okay, it was then the statements or the interviews we conducted with the campaigns managers.
Uh-huh.
Yes, so it's from 5.3
Yes,
of
good.
the report.
Good. And if I understand it correctly, the first interview you had was with the president, and in the spirit of Mail and Guardian, it says in the report he allowed you. I don't think you needed this permission, but I think for the sake of politeness, he then allowed you or led you to speak to the campaign managers.
Yes.
Right. Okay, I think then that is clear. All right. Now, let's then go to that issue. We will come. We'll come to the issue of the what to call it, the code. You remember, there's that issue about using the wrong code and all that. Yeah, but so we're not there yet. Yeah.
Mm.
Now, can you maybe in your own words explain to the committee why you then rejected the the version. I mean, the president could have gone to those dinners and maybe he didn't even know what was being, that after he has left, these people are going to be asked for money. But what evidence did you have to refute the version of the president and the so-called CR17 managers?
Maybe let me say, Chairperson, that when we check what happened, what should have happened, and the discrepancy between what happened and what should have happened, and investigating with an open mind. Firstly, the letter which was written to the president, because I think the South Africa and the world were thinking, okay, this money was for the son. But secondly, when the president wrote to the speaker correcting, he said the money was for his campaign. And it was, okay, the 500,000, which was then paid. So when the letter was written to the president, the meeting was held with him. Indeed, we engaged, we brought the complaint before him, and that, okay, he even said, I was not involved, my campaigns team managers were involved. Hence, following the Mail and Guardian advice or case, then it was for the investigators or the engagements between me and the investigator, Mr. Mataboge. Okay, we need to subpoena all the campaigns managers. We need to subpoena Mr. Fenter, because there was an affidavit going around of Mr. Fenter. We need to subpoena the PA to Mr. Watson. We need to subpoena Mr. Watson. We need to subpoena the bank statements. We need to subpoena every document which will assist us in this particular aspect. So it's not just a question of saying, Mr. President, you are saying, okay, you are not part of the process. Okay, thank you. That's it. So we had to, because we have an inquiring mind, we cannot just receive information. I think there's a paragraph in Mail and Guardian which is still going to take us through. And for the public to understand that if you have an inquiring mind and you are an investigator, and that's what we do as the public protector, we're not just receiving a complaint, go to the department or to an individual and say, there are these allegations, you respond, okay, we close the matter. Being a public protector and investigating, you must go to the root and to the truth. And it's not only the information which we listen, like what the newspaper is saying, and we take it as gospel truth. We need to go beyond or behind the information. So there's a difference between information and evidence. And most of the time, we rely on the evidence. Information, we use it as a lead. In other words, if something is published and there's this thing which was before Parliament and the president has written this and is telling us this is what I said, then we'll have to go deeper and find out. So I think I wanted to give that context before I just say, yes, I didn't believe it, because it will be as if I went into the investigation with a closed mind. But then we had to go and interview all these people, and the recordings are there, the transcripts are there, where you will see, and the report is very clear, why we didn't take this information and why didn't we take his version, because it was not only the first time where we met. The investigation, we investigated, we had to go through every documentation and then prepare what we call a Section 7(9) notice, where we are saying, you are implicated, these matters are substantiated. Your version, originally when you responded, we are not considering it. But then here's the evidence which we have. Can you rebut this?
Yes, no, thank you. I think that's very helpful. That's exactly what I think we're trying to do, to say, it's not like we're saying you just woke up with some conclusion. We want to trace the journey from the complaint to the findings. and to the remedial action. And what happens in between is how you got there, which is really what you're charged for. I don't think the committee sees it as his job to say this conclusion is questionable as a conclusion, but its job is to find, and the court's job, by the way, is to find how did you get there. Whether the conclusion is right or wrong is not. That's what we lawyers call the difference between an appeal and the review. An appeal is to check whether the outcome is correct. But in a review, that's not what the court is interested in. It doesn't care whether it's correct or not. It's interested in the journey. How did you get there? Did you break the law, quote unquote, in reaching that wrong conclusion or incorrect conclusion? All right. Now, okay, fine. So am I correct then, for the benefit of the members, that in what I've now called the journey, there were 3 signposts. First one was the president, because after all, that's the person who's accused, correct? Who's complained against. Sorry, maybe accused is a strong word.
Because
the complaint is against. Yeah, okay.
We're not a criminal court.
Then the second signpost is you speak to him as the person, and then he says, it's like someone accuses me, then I say, or complains against me, then I say, no, it was not me, it was my juniors. Then you have to go to them, right? And then the second, in the spirit of male and guardian, of following the truth, so to speak. Then the second signpost is the emails. Then that led you to the emails. So those were the 3 signposts, if you like, of how you then reached your conclusion. Correct?
Yes. Remember, which I need to put it into context, is that when the investigation is ongoing, writing letters, person responding, interviewing everyone, subpoenaing bank statements, subpoenaing any other information, and that inquiring mind. Yes. So the Section 7(9) notice as well, it's still during investigation.
Right.
So at that particular time, you're still receiving information. So, and that's when you find that there would be evidence which you will get. We're coming to the other reports, which we'll have to deal with. We're at the stage where you need to decide, is this critical information to utilize? But since it's critical, you might as well include it so that when the matter is reviewed, they can also see that this is the information you've gone through in the process. So that's all the evidence which we consider.
Good.
True.
Thank you. Yes. And I think that accords with what I think Ms. Bawa put to Ms. Mkhwebane, if I'm not mistaken, in the context of the rogue unit report, that if some critical information comes up even 2 days before you release your report, you would then have either to reconsider. You can't just say, well, I'm not going to look into this, even though it's critical, as long as the report has not yet been released. Correct?
As long as, definitely, because it's still part of the investigation up until the end of the investigation. Yes, if the information is so critical that you didn't even reference it, or you would want to hear what the other side is saying, definitely, sometimes we will issue supplementary Section 7(9), or as well call a meeting and say, there's something like this, can you clarify? Because that is still part of the investigation. Yeah.
Good. All right. Good. I think now that is clear, then let's then go through all those stages.
Mm. 'Cause- 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 'cause-
the majority judgment in the unanimous judgment in the High Court and the majority judgment in the Constitutional Court reviewed and set aside your report, correct?
That's correct.
Right. And just so that, again, there's no confusion, you don't, this is not an appeal court where we are. So
Correct.
we're not here to say, no, this is what it's not like a higher court, quote unquote, or forum than the Constitutional Court. So we accept that the judgment is the judgment.
We accept, yes.
Yes. But that's not what this committee is all about. This committee is about checking your state of mind as to how you arrived at your conclusions, for better or for worse. But that's what we're, quote unquote, inquiring into. Right. Okay. So let's walk.
Maybe let me clarify this.
Yes.
While still at it, I know we'll come to that. The issue of, yes, the judgment of the High Court and the judgment of the Constitutional Court, based on what it has been said. And indeed, this committee won't review that. But the fact of the matter is, if it's based on wrong facts, and if it's based on information which I don't agree with, indeed, I will indicate that that's not the case. This is what was in my mind or in our mind when we were investigating this particular information. So just to prove that the issue of intentionally or grossly in a negligent manner, I conducted the investigations. Yes.
Absolutely. Thank you. No, I think that in that exchange we had with the chair and Ms. Bawa, that's really where the nub of the issue is. As we said, the drafters of the rules of Parliament, in their wisdom, decided, for example, that negligence, ordinary negligence, which we call culpa, is not enough. So even if it could be found in a particular case that you were negligent in this sense, in the legal sense, that you can't be impeached for that. The drafters of the rules decided in their wisdom that they must put that adjective, that it must be grossly negligent for it to constitute an impeachable offense, and that for reasons that Ms. Bawa and I will debate when we do the closing remarks. But I think, yeah, that's an important point. Right. Now, with all these pools and people and interviews and sections of 29 and out the alteram partem and this meeting, the first meeting with the president, the second meeting with the president, and all that. We then come to, you made certain findings, correct?
That is correct. Actually, the findings were in the section 7.9 notice.
Right. The provisional findings, let's call them that. The provisional findings, yes. Okay. And those provisional findings then typically then will be given, if I'm the person complained against, you give them to me so that I can criticize them and say, no, you shouldn't make those adverse findings to be final, and then you assess that.
Yes, I think during this investigation, what transpired is that, as I said again, the chief investigator was the one who was investigating this matter. The chief investigator was then in constant communication with me on the evidence, the information they are collating, how to deal with certain information and evidence, how to analyze. So Then when the final drafting and analysis of information, which is done by this investigator, and then being drafted, and then I was receiving drafts on this particular matter, and that's where the issue of, okay, possibly here you can improve, here you can add more information, here you can go further and interview the following people. So it's that process. It's not a question of just receiving the information and the responses, drafting, and then boom, it ends there. So it's work in progress, which goes through various stages. And when that is also served, the Section 7(9) notice, the recording which we have here, that's where the president was taken through that, the Section 7(9). It was not just a question. Sometimes we just send it to implicated parties. But in this particular instance, because of the level of the president, and because of the closely guarded investigation, where when the Section 7(9) notice was drafted and completed, the acting chief investigator, the chief operations officer, Ms. Baloi, was then also invited in my boardroom, where I took her through the report, the draft, in fact, that Section 7(9). And I said, you will also accompany us to meet the president, but this is the document which we came out with. The fact of the matter is that I didn't want it to go through all the stages of, now it's a submission, this one is receiving it, now this one can copy it, can do this. I think it was purely for securing the integrity of the investigation, but to protect as well the person we are investigating, to protect any person which we got the information from. So yeah, that's what happened in the investigation.
Thank you, Advocate Mkhwebane, Public Protector. We will pause there for 10 minutes and take a tea break.
Thanks, Chair.
Thank you.
Recording stopped.